Hello, I'm attorney Paul Whalen from Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. All of our fees are based on a sliding scale, which is based on your income. That means the less you make, the less you pay. Today, I want to talk to you about the criminal charge of assault and battery on a family or household member. So we've already talked about assault and battery in the past, what you have to prove for that. Now, this is specifically a crime that is aimed at a particular group of people, a protected group. Uh, in Massachusetts, the domestic violence statute is called assault and battery on a family or household member. So you have to have, in order for you to be found guilty of this crime, the Commonwealth, that is the prosecution, has to find or has to prove four different things in order to win their case. First, that the defendant touched the person of the alleged victim. So there was a physical touching. Number two is that the defendant intended to touch the alleged victim. Number three is that the touching was either likely to cause bodily harm to the alleged victim or it was offensive. And the fourth element that must be shown, and this is what distinguishes it from other assault and battery cases, is that the defendant and the alleged victim were family or household members at the time of the offense. Now, this statute is a little confusing in its terminology because what is a family or household member? So, in just taking the words as we commonly use them, you would think that a family or household member would be somebody you're related to, a blood relative, your parents, your brother, your sister, something along those lines. But that's not the case. This is the domestic violence statute. So it is intended to protect people who are in a what's called a significant dating relationship. So in order to prove the fourth element that the person, that the defendant and the alleged victim were family or household members, the Commonwealth must prove that they were family or household members under the statute. And that means that they were either they were or are married to each other. Number two is that they have a child in common. Or number three, that there was a substantive dating relationship between the two parties. So let's break that down for a second. So the first is that they were or are married to each other. So that's easy enough to distinguish. Whether they were married or not, that's pretty clear, or can be proven pretty clearly. Number two could be that they have a child together. Also, that's something that is fairly easy to establish. However, it could be that paternity on the part of the father has not been proven, and therefore, if there's a child that's in question, the Commonwealth would have to prove that that child is the child of both the defendant and the alleged victim. And the third way of showing that they were that they were family or household members is that they were in a substantive dating relationship, either at the time or at some time in the past. In order to go into that and to prove that there was a substantive dating relationship, they look at several elements of that as well. Number one is the length of the time of the relationship. How long were they in that significant dating relationship? Number two is the type of relationship. There has to be a dating relationship, a romantic involvement, if you will. And number three is the frequency of interaction between the alleged victim and the defendant. And number four is the length of time that has elapsed since the termination of the relationship. Now, the relationship doesn't have to be exclusive or a committed relationship. It just has to be substantive, as is interpreted by the jury if it ultimately goes to a jury trial. So a couple of cases have sort of helped define what is a substantive dating relationship. One case is said that a single date out to the movies is not a significant or a substantive dating relationship. There was another case where two parties were actually even in different countries. So there was a young woman who had gone over, I believe, to Europe, was over there either on vacation or studying through school. In any case, was in a relationship with a man that was over there. She came back to the United States. He remained there. they were in contact with each other. They were emailing, texting, all that sort of stuff. But they were on two different continents. But they shared a desire to be together. They exchanged romantic or sexual messages back and forth. And the court had determined that they were, in fact, in a substantive dating relationship, even though they weren't physically near each other. They were in a significant dating relationship. So those are the kinds of things that a jury will look to, that the Commonwealth needs to prove in order to find you guilty of a assault and battery on a family or household member. As I say, it's a confusing sounding statute, but just think of it, it's domestic violence. So it's between boyfriend, girlfriend, 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 boyfriend, boyfriend, husband, wife, whatever it might be. That's what you look to when making that determination. Besides that, you have to prove all the other elements that come with any assault and battery charge. That there was physical touching and the offensive, it was offensive or intended to be cause bodily injury. Those are the things that happen in every assault and battery case. And this is with the caveat that it needs to be someone in a particular group of people that would give additional protections. Because what happens is, in a domestic assault and battery case, there are other punishments that go along with, if you're trying to plea somebody out to the case, or if you're found guilty of it. For instance, there's a batterer's intervention program that's required, unless the judge puts on the record that that's not required, which is very rare indeed, but it does happen. But so those are the kinds of things that you look to. Domestic violence obviously is a very serious matter, very serious crime, and is treated as such in the court system. So that's assault and battery on a family or a household member. As I say, at a Ford Law, we do practice criminal and family law throughout Massachusetts. We want you to be able to ask us any questions, get the help that you need, because for far too long, the hardworking people of Massachusetts have been sort of left behind by the criminal justice system and the family law system as well. So we're trying to do everything we can to represent you as best we can at an affordable rate. Feel free to visit us at affordlaw.org, and please feel free to book a free virtual appointment with me. I would be happy to answer any questions you might have about family law or criminal law questions in Massachusetts. Because at Afford Law, we're making justice affordable. Thank you.